Good afternoon, DA's office.
Hi, my name is Sean Floyd, and I have a few administrative type questions. I think probably the best person to speak with about it would be Felicia. I don't know her last name, but if she's available.
This is Felicia.
Oh, it is. Hi. Yeah, I just had some, uh, like I say, administrative things about Discovery I wanted to discuss with you.
Okay.
It'll take like maybe 15 minutes or so, I'm going to guess.
Okay. I'll do my best. I do. I don't know if I have 15 minutes, but go ahead and I'll see what I can do.
Well, if you don't have, I mean, maybe I should call back, is what I was going to suggest. That's why I brought up how long it would take.
Okay. Well, give me an idea. What's your question?
Well, it's sort of several. It's like it's some several administrative kind of things. I mean, it's a bunch. There might be several questions.
Process issues, or do you have your Discovery? What?
Well, let me I guess put it this way. The other day when we spoke at some point, I don't remember which time, but one of the times we spoke recently, you said that your job is to provide me with the Discovery.
Mm-hmm.
Yeah. So I just want to. Well, I've got this felony case likely coming up, and the disorderly conduct charge is about to go to docket call later in the week for jury selection, and so I just want to. There's some things I need to cover to do with Discovery, and you're providing it to me, and so like that's the nature of what I'm talking. What I
Are you missing part of your Discovery?
Sort of, yeah.
Okay. What do you think it is that you're missing?
Well, could we just please can I just go over this with you? I understand what I need to cover with you. You don't, right, at this point. So I can rather than you directing me, and I it's all relevant. Trust me. I mean, but it's going to take a minute. Hello?
Thank you for contacting the Waldo County District Attorney's Office anytime during this message.
Hello?
Hi, is this Sean?
Yeah, I think we got cut off.
Yeah, I'm so sorry. This is Felicia. I hit a button and hung up by accident. I'm so sorry about that. So you were in the middle of explaining your Discovery issue. I think where we left off is you were just going to finish up telling me what it is that you need.
Well, what it is I need is like 15 minutes or so of your time to just go over some stuff.
Okay.
So if
go
you
ahead.
Oh, okay. That's yeah, okay. That's great. Thank you. So do you have a copy of the main rules of criminal procedure handy, because I'm going to be referring to it?
I don't.
Okay, well I'll just read from it then. I mean it's understandable enough, I think. So Rule 16 is what I'm looking at. It's discovery by the defendant, automatic discovery. Part 1 says the scope of automatic discovery, and it reads: the attorney for the state shall provide as automatic discovery all matters set forth in this subdivision that are within the possession or control of the attorney for the state. So that's stuff that you guys already have. And then it goes on to say that the obligation of the attorney for the state extends to matters within the possession or control of any member of the attorney of the state staff and of any official or employee of the state or any political subdivision thereof who regularly reports or who, with reference to a particular case, has reported to the office of the attorney for the state. Which, now that's a lot of words there, but that would definitely include the summonsing officer in a case, for example, or the arresting officer in a case. Excuse me, does that make sense? Sort of?
I'm confused as to where we're getting here. What is it that you need from me?
Well, we are getting there. Like I say, it's going to take a minute.
So yes, it makes sense.
Okay.
Go ahead.
It's going to take a lot longer if you interrupt and ask that question every single time. I mean, if you can just follow along. Like I say, I'm referring to the rule. I'm just going to go over some stuff in it. If you know.
But Sean, you're going to have this opportunity when you are in court.
No.
I talked with you about that the other day.
No, this is something. This is administrative stuff. Has nothing to do with my questions of the other day. Well, except in as much as it's this, same case partly. Has to do with you and you providing discovery, as I stated a while ago. Okay. Okay. That you said that's your job, right?
It is. If there's something specific you're missing that you're requesting, I'm happy to try to get that for you. But we shouldn't need to take 15 minutes to talk about what that might be.
Well, it's not just one little thing, though. That's the thing. There's a bunch of stuff, and we have taken 9 minutes or so already, and it's just been you objecting to me just going over this stuff.
I'm not objecting to anything. If you want to go ahead and just tell me what it is, then I will not interrupt you. Go ahead.
Okay, but it's going to take a minute, and I may just ask if what I'm saying makes sense. Okay, so just so that I know that it does, because otherwise there's if you're not following along, there's no point really in me continuing. Does that make sense?
Sure.
Okay, so basically, the scope of automatic discovery is what you're supposed to provide is anything in your control, anything in the control of the summonsing or arresting officer, boiled down. Now, the duty of the attorney for the state, it continues, part 2 of this rule, is that you shall provide, your office shall provide the following to the defendant, which is me. A says the police reports and any other documents. Hello?
Yes, sorry.
Oh, that's okay.
I've got someone at the window, but I think someone else will get it. Go ahead.
Where was it? The police reports and any other documents used by the prosecutor in deciding to charge the defendant, and that was provided in the disorderly conduct case, which is one of the cases I'm calling in reference to. That was provided at my arraignment appearance, which is fine. But then if you skip down, Part F says any books, papers, documents, electronically stored information, photographs, including motion pictures and videotapes, and some other stuff. But that's the video basically would be included there, and that's Part F. Part I is written or recorded statements of witnesses and summaries of statements of witnesses contained in police reports or similar matter. And the recorded statements are included there. Summaries were provided in that case. The the recorded statements were eventually provided. But then we get to see, it's not just a matter of, you said your job was, and you're correct, I'm sure, is to provide discovery, right?
So what my job is to provide you with the same information that I have.
Okay, well then maybe you are not the correct person to discuss this with, because what I am talking about here is, see, I'm referring, like I said, these are the rules that your office is supposed to be following.
Well, if there's something specific that you want to request, though, we also do that.
Okay, yeah, yep.
Okay, is there something specific that you want to request?
There is, and we will get there. I promise. Yep.
Okay.
But that so far that makes, in some sense, your job is to provide discovery. And the point I was going to make is, it's not just to provide that discovery, or your office's job is to provide discovery, but it's no good to me if it's not provided in a timely manner. If you don't provide that discovery, for example, until after my trial, obviously it would do me no good at all, right? So that's just, I mean, obviously that's not what I'm complaining about, but just an example of what, why time is obviously a factor in what you do as well. And then and the reason I bring that up is because I'm at part B here.
So, can I put you on hold just for a second? I just had somebody else walk in. I'm going to put you on hold.
Yep.
Thanks. Hi, Sean. Thanks for holding. Sorry about that.
Sure. No problem.
Okay. Go ahead and continue.
Well, just real quick, just to kind of sum up. So, your office's duty is to report, among other things, the police report and written witness statements, which was done. Also, video and body cam, which was eventually done. And then the recordings of statements, which was also done on the body cam in the case of the disorderly conduct case, is supposed to be provided as well. And the time for that is, there's a couple different situations, one of which applies to the disorderly conduct case, and one of which applies to this felony witness tampering case. So I want to go over them both.
Okay. Which one are we going over first?
Okay, the first one is with regard to the disorderly conduct charge.
Okay.
And it reads as follows: at initial appearance, on a Class A, B, or C charge. Actually, this applies to the felony witness tampering as well. But it's not, an initial appearance on a Class A, B, or C charge, or arraignment on a Class D or E charge, the attorney for the state shall produce and allow the defendant to review the information described in subdivision A to A, which was done as far as that's the police report and the written witness statements. That was done as far as the the disorderly conduct case goes. So I don't have an issue there. But my initial appearance on the Class A, B, or C, the Class C felony charge, I wasn't provided with that. It was provided to my attorney, or not my attorney, to the attorney for the day. Handelman, I think his name was, but I never accepted his representation. I represented myself because he said he would keep me in there. So I said, no thanks, I'd rather leave. And so so I didn't never accept. But I never got it from him. I never got it from you all yet. So I think that's due to me, if I'm not mistaken, at this point. the police report on that. Does that make sense?
Okay. Yep. I'm looking for it right now to make sure.
And the written statements, the written witness statements, which would be only Danny Rock, I believe, would be the only. Although it's possible they talked to the folks at Restorative Justice. But Dan Rock is the only one I would be concerned about. If you don't, if you could just make a note of that, I don't need it immediately.
Well, it's on its way. It's
Okay.
actually, it will be momentarily. You'll have it in your email.
Oh, okay. So
the share file will notify you.
Okay, good enough. So now there's a share file for that. For the witness tampering case, I'm assuming as well.
Oh, that's what I thought we were talking about.
Yeah,
from the date of offense, May 13th.
Yes. Yeah, I had not seen that. I have not had access to my email for a few days, so I haven't seen that. Yeah.
Okay. Sean, while we're on this, could you tell me your email so that I can get you added to it?
Oh well, yeah. You should already have it because I already have 2 other files in there, but it's SeanJFloyd@gmail.com.
Okay, I just wanted confirmation. We did have that email. I just wanted to confirm that's where you wanted it sent.
Yes, please.
Okay.
Okay,
right.
so that
is being done right now.
Awesome. Okay, well, that's good. And then part 2, and this applies to the disorderly conduct case, and it is for future reference at this point, because what it says is, after a defendant has entered a not guilty plea to a Class D or E crime, in the manner dictated by subdivision A4, which just isn't relevant, the attorney for the state shall provide the information described in subdivision A to B through I, which is the video, the body cam video stuff that I was talking about before. That was part in F. I is the recording of the witness statements, which in this case are the same thing. But here's the thing. It says within 7 days after the arraignment or entry of a written plea of not guilty.
Mm-hmm.
Okay, now that arraignment occurred on October 9th of last year.
Mm-hmm.
And 7 days after that was whatever, the 16th of October. I didn't receive that stuff. And then on November 6th, I went up there to your office and I spoke with Eric Harvey, and I requested that information. He told me I would be given it, and I was never given it. And then on December 6th, Attorney Toothaker took over my case against my wishes because of a clerical error at the court, and your office would no longer communicate with me, and he wouldn't communicate with me either. So I had to take care of that, which I finally did. And then once I finally got him to withdraw on the 14th, then I was provided with that stuff. The 14th of April, I should say, of this year. So like 7 months after the arraignment.
So if you're ready for my input now, I would tell you that you would not have received it within that 7-day period, because at that point in time, I know you didn't want to have Jeff Toothaker, but we have to follow what the court has.
No, wait. You did not understand. I asked for it before he was assigned. On October, I did not have an attorney for like 2 months, and
you must have been handed the packet at your arraignment, just like everybody else. So on that day, we have the discovery packet.
Right. Well, yeah, but it did not include the body cam video, which it is supposed. It wouldn't
include that because
no. On the day, you're right. On that day, you're right. But within 7 days after arraignment, it's right here in black and white. I'm not like making this up. This is the rules, the main rules of criminal procedure that your office is supposed to follow in black and white. This is not just me like saying you need to do this because it's my right to whatever. This is in black and white what you are supposed to do. Within 7 days after the arraignment, you are supposed to provide, not on that day, but within 7 days after that arraignment. I'm supposed to be getting that. In that case.
Okay.
Now, I was not provided with that, and I'm provided with it. I have been provided with it now, and that's great, but just for, like I say, for future reference, that's what's supposed to happen according to the main rules of criminal procedure. Okay? Does that make sense?
Sure.
Okay, so then, and this is kind of an answer to a question that you asked before. If you, well, I was going to say if you skip down in the to another page, but you don't have the rules handy. But the discovery upon request. I'll read it to you. It says, a defendant may make a written request to have the state provide any other books, papers, documents, electronically stored information, photographs, including motion pictures and video tapes, or copies or portions thereof, standard stuff, relevant to the preparation of the defense. And you asked earlier about me and written requests or putting in specific requests. And I did. You should have on file on the 14th, the same day I got Jeff Toothaker to finally withdraw, I submitted a written request in accordance with the main rules of criminal procedure, Rule 16, and and yeah, and it's very detailed. There's a bunch of stuff, and you're supposed to response by the attorney of the state is upon receipt of that. It says you have certain obligations. At the very least, you're supposed to notify me in a timely manner that you, within 14 days, sort of, that you object to the request if you can't provide it, if nothing else.
What date did you say you sent that on?
The 14th.
Of what month?
Oh, I'm sorry, of April.
Of April, okay.
Yep.
And who did you send it to? Was it by mail, email?
I sent it by mail to your office. I submitted it in person at the court.
Okay. So I'm not the one who would have handled that part of it. We give our specific request to Eric, and then we would then reach out to the officer or law enforcement department to see if that's something that is available for us to have. That's how that process works.
Well, none of that has anything really to do with me. Your obligation as an office is to provide me with that. I don't.
If it exists, Sean.
Well, oh yeah, all this stuff, at least some of this stuff exists. But like I say, at the minimum, I was supposed to have, in some sort of timely manner, received some sort of response. And that hasn't happened, and that was like 2 months ago. So, or not quite, but almost. Anyway, so maybe you could just mention to Eric, or whatever you do internally that's not my prerogative, that's your deal. But you know what maybe you could mention to whoever needs to be mentioned to that. Okay. I sent that in.
Can we back up for just a second? I'm writing a note here. So on April 14th, 2025, you mailed us a request for what? Can you tell me what it was that you're requesting?
Well, it was
for which case?
That it was for the disorderly conduct case, and it was a list of stuff. I mean, it's a long list. I wasn't sure what was available exactly. It's basically repurposed FOIA requests or Freedom of Access Act requests. Which they refused, BPD refused to comply with, and I kind of repurposed them as like
okay.
body cam footage.
Okay. So I found in the file. So you're looking for names and badge numbers of all officers involved.
Well, I mean, there's a bunch of stuff. Like I say, I'm not sure what. Yeah, I mean.
Footage, non-emergency. So a lot of these things are things that are already provided in the discovery, though.
Not body cam footage from this incident that occurred during a Belfast summer nights. No, this is.
I think what I'm going to do now is, as long as you're okay with it, I would like to pass you on to Eric so the two of you can discuss these things, because he likely has already requested some of them. So I just want to ask him if he knows the status, where we stand on any of these. If there was, often we get requests like these all the time from attorneys, and we provide what we can. It has to exist in order for us to have it and to disperse it.
But not to keep me notified in a timely manner about what's going on with it.
Okay. I apologize that maybe the time hasn't been soon enough, but I will pass you on to Eric so you two can discuss it.
Okay, and just for context here, Felicia, I am facing 6.5 years over this stuff. So this is not, an apology is nice, but you know what I'm saying? This is a serious thing. So thank you for your time, and I'll speak with Eric.
Okay, thank you.
Might have made sense for me to speak with Eric to begin with, but here we are.
Good afternoon, DA's office.
Hi, this is Sean Floyd again. Sorry.
Hi, that's okay. Sean, I'm actually, I can put you on hold again. It won't be long. Bill is actually prepared to talk to you now, if that works for you. Eric wasn't available.
Okay. Actually, see, the thing is, what I was calling back to suggest that I call back because I have something I need to do coming up here, and yeah. So can I just make an appointment to talk to Mr. Entwistle whenever is convenient for him in the near future, like. Let's see. It's Monday. Wednesday would work for me. Thursday would work for me. Anytime.
I am not sure about. It's definitely not Thursday. He's not available Thursday, but Wednesday. There's a possibility of afternoon. He's prepared to talk to you right now if you have a minute.
Yeah, okay. Well, I guess why don't we do that? Hopefully it won't take too long.
Sure.
Yeah.
Hang right on.
Thanks.
Hey, this is Bill Entwistle speaking.
Hi, this is Sean Floyd.
Hi, Sean.
Hi. I'll kind of cut to the chase here because I'm in a little bit of a hurry at this point. I already addressed a lot of what I had to address with Felicia, and it's stuff that kind of has already happened with regard to the disorderly conduct case. And I was about to get to. I also needed to address a couple of things with regard to the witness tampering case. And so that, I'll just cut right to that. I don't need to rehash that other stuff. And what I need to know, my understanding is that on the 24th, that's a dispositional conference?
24th of June, yes.
Yeah, okay.
Yep.
So now, according to the main rules of criminal procedure, when a dispositional conference is to occur before indictment on a Class A, B, or C crime, in the manner dictated by Subdivision A4, the Attorney for the State shall provide the information described in Subdivision A to B through I I'm reading for the main rules of criminal procedure here. No later than 14 days before any dispositional conference that occurs before indictment. So that's coming up. That would be the 10th of this month. And amongst those things that I am due, and just want to make sure that I get in a timely manner, are the police report and written witness statements, which may have been provided to, I think his name was Handelman, who was the attorney of the day at my bail, in my initial appearance of a bail hearing, I guess it was, right? But I never got them. But I would like them, as ASAP, of course. And then the body cam isn't particularly relevant here, but the recorded statements particularly by Dan Rock, recording of the phone calls that he made, all that stuff is in possession and control of the police and by extension of your office. So I am due that by the 10th of this month. So that's in next Monday or Tuesday or whatever. So I just want to make sure everybody's on the same page as far as that goes, and I get that in a timely manner.
Okay.
That's all. I just if you're going to provide that, then I don't have any issue. Because there have been issues, but like I say, I already kind of addressed them with Felicia. So my concern is more that they don't occur with regard to this witness tampering case. So as long as you're reassuring me that they won't, that what I just described will happen as per the main rules of criminal procedure, then I think we're good.
Okay.
Okay. Well, that was easy.
All right.
Okay. I'll see you in court.